Good afternoon and welcome to the Appellate Division First Department. We have approximately 6 hours of argument time requested, so I have to ask you, although it doesn't seem that there's so many people for 6 hours, but I have to ask you to please just ask for the amount of time that you really need. Remember, we have had your briefs and your records, and we are familiar with the cases and are just trying to hopefully have you answer some of the questions we have about your cases. So I'm going to call the calendar. The appellants and respondents should stand up, and you'll tell me how much time you need based on that. So the first case on the calendar is People versus Henry Bonilla. Submitted. 195 East 76th Street versus 197. Nobody? Submitted. The third case, G.T. Maria, is submitted. Cutrone versus Airco International. You want any rebuttal time? Okay, okay. Okay, 5, 2, and 6. Thank you, counsel. De Jesus versus 935 Bronx River. Appellant. Respondent 935 and respondent M&M. Okay, I'll give you the appellant 6 and 2, and I'll give each of the respondents 5. I'm not sure you'll need all that, but okay. Booston LLC versus 35 West Realty. 7 and 2. And respondent? Okay, I'll give you 6, 2, and 6. If we need more, we'll keep going. LL 410 East 78th Street versus Division of Housing. Submitted. People versus Juan Requena. Submitted. Tower 570 Company versus Miller and Rubel. And respondent? Okay, I'll give you 6, 2, and 6. Thank you. Francis versus 3475 3rd Avenue. Is the appellant back? Okay, you got back? Okay, good. How much time?
8 minutes.
And the respondents, the defendant respondents? And the third-party defendant? Okay, so I'll give you 6 and 2 for the appellant and 5 and 4 for the respondent and the third-party defendant respondent. Separito versus Branda. And respondent? Okay, I'll give you 5 and 2, and I'll give the respondent 5. Thank you. Zucker Real Estate versus Old Republic. Okay, 5, 3, and 5. Lopez versus New York State Office of Children. You're the respondent, correct? Does anyone have any questions? I don't think so. Thank you for coming in. We'll mark it submitted. You can have a seat. Parto versus Van Owners is submitted, and AC versus DHCR is also submitted. Okay, so the first case for argument is Cutrone versus Airco International.
Good afternoon. May it please the court. Kevin McCaffrey on behalf of the appellant, Dykes Lumber. I'll get right to the point with two words that I'm sure the court's expecting. No causation. Not only under Nemeth or any of the recent decisions by this court, namely Dyer or Killian or Pompani, but I would say under any analysis, even prior to 2022 when all those cases were decided. And that's because what we have offered by the respondent here is markedly insufficient testimony as regards Dykes Lumber and expert reports that don't even mention Dykes Lumber whatsoever. So they're also markedly insufficient. As the court is aware, the facts are few and pretty simple. We have a situation where Mr. Cutrone apparently worked with what's he identified as a joint compound, which may have been supplied by Dykes Lumber on possibly 5 or 6 occasions throughout the course of his life. And I do say possibly because as far as we know, it could have been one time, because the 5 times that are remaining, he based that on the fact that he saw some Dykes Lumber trucks which were possibly at work sites later on in his life. So that's all we have for the facts. And in fact, we don't even know, as far as the testimony and any of the other evidence is concerned, whether or not that joint compound had any asbestos-containing aspect to it either. So that's it for the facts. As for the respondent's expert reports, there's one by Dr. Ginsberg, one by Dr. Staggs. Neither one has any Dykes Lumber specific opinions, evaluations, or data whatsoever. Dr. Ginsberg offers a little bit of a medical history and recitation of the facts underlying Mr. Cutrone's illness, and he ultimately gives us the opinion, that, which is not contested, obviously, that lung cancer can be caused by asbestos as well as smoking. And by the way, Mr. Cutrone was also a smoker, as the court is aware. But there's no attempt whatsoever to provide any data or information regarding what levels of exposure may have been attributable to any products possibly supplied by Dykes Lumber. And that's fatal.
And there was also a Prince Lumber, and was there some confusion to some extent in the plaintiff's mind as to whether some of this material came from Dykes Lumber or from Prince Lumber?
Right, that's also correct, Your Honor. His first recollection of using joint compound, as far as I can recall from the testimony, was he thought it was either from Dykes or possibly from Prince Lumber, and I think that was a job in the late 1960s downtown in the West Village. And again, those 5 subsequent occasions were simply based on the fact that you saw Dykes Lumber trucks showing up at various job sites, possibly 5 job sites. And for all we know, the trucks were delivering wrenches, tools of other kinds. It could be anything at all, because Dykes Lumber was simply a supply store, a plumbing supply store. So that's correct.
Counsel, you can't necessarily meet your burden by pointing holes in the plaintiff's testimony. So is it your position that more so the specific causation just isn't there?
Well, I don't think we have to point holes, because I think the prima facie showing was very clearly made when Dykes submitted an expert report which actually discussed Dykes Lumber. And it actually discussed exposures to Dykes Lumber to the extent that there were any, and the conclusion was it was de minimis and had no adverse effect on the plaintiff's health or Mr. Cutrone's health. So I think that the prima facie burden was shown, in addition to the fact that the actual testimony was at most 5 or 6 times of usage. So I don't think that there's any doubt that we made the prima facie showing. I just think that when you have a report, or reports plural, which come back and essentially offer broad generalities and not even a mention of Dykes, that there hasn't been a rebuttal of the prima facie showing. So that would be our position on that. But in any event, Dr. Ginsberg simply opines that there was a cause of Mr. Cutrone's illness. We don't know what the cause is, and he doesn't even mention Dykes. And then we have Dr. Staggs' report, which I would say is even more problematic, because not only does Dr. Staggs not offer any opinions regarding Dykes Lumber, he also spends a fair amount of time discussing the causes of mesothelioma, and Mr. Cutrone doesn't have mesothelioma. The most that he offers, Mr. Staggs, Dr. Staggs, at the very end of his report, is this conclusion, quote, cumulative exposures to asbestos from each company's product or products, plural, identified in testimony were substantial contributing factors. And that's it.
Counsel, if I may,
yes.
Your expert was very detailed in his opinions. And my question to you is, what, if any, response did the plaintiff's experts provide regarding your experts' contentions?
Sure. It's a simple answer. There is none. There was no attempt to have any sort of rebuttal expert. The opinions in the 2 reports that were offered were general broad-based viewpoints on what happens when asbestos exposure occurs to an individual. Barely anything to do at all, in some instances, even with this plaintiff, or pardon me, Mr. Cutrone. So I would say that under those facts, not only has the prima facie showing been made, but it hasn't been rebutted in any fashion.
Okay,
I
thank
see
you.
my time
You'll
is
have a
up.
couple minutes for rebuttal.
Yes, thank you, Your Honor.
Thank you, counsel.
Thank you, Your Honor. Alani Golansky for Mr. Cutrone. The defendant wholly failed to meet its burden as a movement in this case. They proffered one non-medical expert. That medical expert, a hygienist, first of all, assumed a totally incorrect exposure period for exposure history for Mr. Cutrone. Mr. Cutrone was exposed for 25 years to joint compound. All he did was joint compound. He was a taper.
Well, what about Mr. Cutrone's testimony that it could have been Dykes Lumber, it could have been another lumber company?
Yes, thank you. There were two suppliers of the 5 brands of joint compound throughout the 25 years. It was Dykes Lumber and it was Prince Lumber. Those two suppliers supplied joint compound for 25 years, and Mr. Cutrone used joint compound daily for 25 years. That was his only asbestos exposure. They misrepresent the record by looking at one fact on one page. They misinterpret one piece of testimony on one page to the effect that, well, there were only 4 or 5 times that Dykes Lumber supplied the asbestos. That's not what the record shows. The record shows repeatedly that over 25 years it was Dykes Lumber, and he states that, for instance, repeatedly, page 125 to 126 of the record, page 89 of the record, page 126 of the record. During the whole decade of the 1960s, it was Dykes trucks delivering joint compound as well as Prince trucks.
But Mr. Golansky, after the Court of Appeals decision in Nemeth, I know I was on that case, and we decided it differently here, but we're only the first department and not the Court of Appeals. So after their decision in 2022 in Nemeth, I mean, some of the statements in your expert affidavits just do not seem to create the specific causation that we have been told we need to look for, and that was really my concern.
Yes, Your Honor. Nemeth was a post-trial sufficiency analysis. It did not alter the movement's burden on a summary judgment motion. Here, this one non-medical expert had no foundation, no scientific backup for any assertion he made, no computation of the plaintiff's approximate dose at all by this hygienist, as opposed to what happened in the floor tile appeals. There was no finding or even an estimate by this expert of the amount of asbestos found in joint compound. There was not one word by Mr. Rabinowitz about how much asbestos is usually found in asbestos-containing joint compound. This expert said he had only personal experience with floor tile, insulation, and cement.
Right,
no
but counsel, okay, but let's just assume for argument's sake that the defendant had met their prima facie burden. How did your expert address specific causation?
Yes, Your Honor. First of all, we cannot really genuinely assume that they met their burden. They totally didn't. But our experts were medical experts who opined that the plaintiff's exposures to the 5 joint compounds, and they didn't have to mention Dykes as they keep reiterating. The experts didn't mention Dykes, but there was no reason to mention Dykes because Dykes is here by virtue of the legal accountability it holds for the joint compounds. And our experts show that each of those joint compounds held 13% asbestos by weight. They released ultra-hazardous levels of asbestos. This was the plaintiff's only exposure to that joint compound, that mixing and sanding of joint compound delivered by Dykes resulted in 59 fibers per cc, 600 times above the regulatory limit. Even if you look at the Parker versus Mobile Court of Appeals decision, which everybody relies on, it was the plaintiff's medical history. The defendant has to have an expert that can look at the plaintiff's medical history and look at specific causation. Our our experts did do that. They scrutinized, and they had the qualifications and competence to look at our client's medical history and medical records in the context of his joint compound asbestos exposures, which were his only asbestos exposures, joint compound delivered by their client.
Counsel, if I may, it's really not clear if it's Dykes. And the reason why I say that is because, you know, the plaintiff had testified that he was inclined to believe that he obtained the joint compound from Dykes. And that was only because he saw the trucks at the work site. So he was not able to identify the product whatsoever. And he said, you know, it may be, you know, he was unsure if he purchased the joint compound from Dykes or Prince Lumber, but he clearly said he was inclined to believe because the trucks were there. We don't know.
Dykes' own counsel at the deposition asked Mr. Cutrone, so on page 172, joint compound was purchased from Dykes for these job sites in Manhattan from in 1960 through the 1970s to the mid-1980s. Is that correct? And the plaintiff answered yes. So Dykes' own counsel established that it was, and confirmed that it was Dykes Lumber that supplied all of this joint compound, 125 to 126. Who were the particular suppliers who delivered joint compound? The suppliers were Dykes Lumber and Prince Lumber. He can't go through the entire, you know, several hundred pages of deposition testimony saying all this joint compound came from Dykes, it came from Prince. I don't remember exactly which job sites it was Dykes and which was Prince, but I saw those were the trucks, those were the suppliers that delivered all the joint compounds. So we don't have to show that it was at a specific job site that it was Dykes versus Prince, because if you get to that level of specificity, no plaintiff trying to recall occupational history 25 years previously or 40 years previously is going to ever be able to do that. But it's not necessary because he identified Dykes and Prince, and they supplied joint compound interchangeably. They were both the suppliers and responsible here.
Okay,
Thank you, Your Honor. Thank you.
You have 2 minutes for rebuttal.
Yes, briefly, Your Honors. Obviously, the court understands the facts. I think that they were not represented entirely accurately just then. I won't go into those. The record's clear on that. I will say this in terms of what has been represented as a quote-unquote non-medical or perhaps insufficient expert because the expert proffered by Dykes was an industrial hygienist. That's flatly wrong in every respect. In fact, this court in Pompani specifically relied upon the exact type of report by the exact type of expert in dismissing a case that was very similar to this. So I don't think there's any doubt that the prima facie burden was actually met. And I think all the data points that were just cited by my esteemed opposing counsel, the court has to keep in mind were all generalities generated by looking at the entirety of this gentleman's exposures and referring them to all exposures and all products. So again, we have the same problem. The problem is there's no Dykes Lumber specific evaluations, data points, conclusions, what have you, with which to base an opinion on. The court has to take a look and see whether or not there was any rebuttal of the prima facie showing. I would say there certainly wasn't. Finally, I'll leave the court just with this. In Dyer, which was, of course, decided by this court, I think, halfway through last summer, the court indicated that sometimes it will be difficult, sometimes it will be impossible to meet that burden on behalf of the plaintiffs. And I would suggest that under these facts, at least with respect to Dykes, it's impossible. You can't have this sort of a de minimis exposure and expect an expert on their behalf to come in and actually with a straight face say that this level of de minimis exposure is going to cause or contribute to lung cancer. And I think, frankly, reading between the lines, that's why they didn't make that conclusion. They can't. So unless the court has any questions.
Okay, thank you very much, counsel, both of you. Have a good afternoon.
Thank you, Your Honors. Thank you.
The next case for argument is De Jesus versus 935 Bronx River. Good afternoon, counsel. You may begin.
Good afternoon, Your Honors. May it please the court. We are here today, Judge, and I am asking this court on behalf of the plaintiff appellant, Anthony De Jesus, to correct this the lower court's decision that summarily dismissed the entire case, all 4 causes of action that were asserted by Mr. De Jesus in his complaint. We believe that the court misinterpreted and misapplied the applicable provisions of the labor law.
Well, I mean, before we even get to that, how is your client fall within the class of persons who are subject to the protections that are afforded under the labor law? He was not a construction worker. He was not involved in construction or renovation or whatever. He was just there. He worked for the auto supply, didn't he?
The auto supply was owned by Dominic Ferravecchio. He was also the owner of the building and
Right.
multiple other businesses.
So your client was doing, a little bit of this work and that work and checking on properties and stuff, but he wasn't doing the kind of work that falls within the scope of a labor law plaintiff, was he?
Yes, he was. He was a supervisor of safety, and that was what his role was, and that's what he was tasked to do.
Counsel, I thought that he was employed to oversee the removal of the glass that was left by the tenant.
That was one of the functions that he had with regard to that particular space. The other was to make sure that it was done in a safe manner. He was also referred to commonly as the maintenance man because he supervised all of the activities within the building. Mr.
But
Davis,
how is he, but doesn't he have to, certainly with 241-6, which, this might be otherwise, performing construction, alteration, demolition, or similar labor? I mean, how is he doing any of that?
as a site safety manager for the building, which is what he was supervising safety.
Well, counsel,
And
let me-
241-6, let me
Wait,
just
wait,
preface it, does
Wait,
not
let
require.
let my colleague ask.
Let me just direct you, I guess, maybe a little bit closer to, in your brief, you cite specifically 2 cases, Ellison and Detain. And in one of those cases, it was an excavation. One was a construction site. There were other cases involving sheetrock removal. What was your client doing in that regard so that it would fall within the ambit of the labor law?
There was construction going on by everybody's testimony, both plaintiff and defendant witnesses, throughout the building. Part of that construction involved the dismantling of this warehouse where there was auto glass, and the dismantling of that is construction activity that is part of the purview of the labor law.
What was, I get that, but what was plaintiff doing, and where do you have testimony that he was actually the site safety person?
Labor Law 240 sub 1 requires a certain type of activity be performed. Where the lower court erred was putting that on the side. Labor Law 241 sub 6 does not require that he be a construction worker. It requires that he be lawfully frequenting the premises.
Well, let me
My
ask you this
client's
question,
office was in
counsel.
the building.
Let me ask you this question, because obviously, you know, his main job was to sell automobiles, so.
Incorrect.
So, excuse me?
Incorrect. 100% incorrect.
Oh, okay, well, you know what, I'm gonna stick with what the record says, because, you know, we have testimony, I'm still speaking, thank you. You know, we have testimony that, yes, he did other jobs, but the main job was selling autos. So this is what I would like to know. We know that renovations were taking place in the building. Can you point me to anywhere in the record that he was engaged in the renovations or he was asked to? Because the testimony here in the record says he was not asked to do any of those things.
Okay.
I'm certainly not a safety manager, but if you can point me to the record, I'll look at it.
Okay, Jonathan Lunan, who testified on behalf of 935 Bronx River, made a specific statement that Mr. De Jesus was to make sure that things were done safely. He could have taken alternative steps. He didn't have to go and remedy the situation himself. However, we're losing sight of the fact that he was lawfully on the premises, 241-6. He was lawfully on the premises. His office was in the building. He had a right to be in the premises. More importantly, summarily dismissing one cause of action doesn't get you to dismiss the negligence cause of action, which is common law negligence, doesn't require that he be in any protected class of worker. It just requires that there be a duty and a breach of duty. We were the only party to submit an expert that clearly made a link between a specific statutory violation and the incident and damages. That was uncontradicted by anyone in any paper. So I think.
But is that an expert's purview to interpret the law and to opine upon the applicability of the statute, right? That's not necessarily what the expert is there for. That's a question of law left to the courts.
I think, I'm not sure I understand what you're saying, but I'll answer it this way. My expert gave violations specifically of the labor law. It's up to us to prove proximate cause, okay? But what we're talking about here is an additional cause of action based on common law negligence. No one put in anything to dispute the fact that the hanging electrical wire in its live condition was negligent. That is at the very least a triable issue of fact. It was undisputed by anyone. It wasn't even opposed in the lower court's papers. It wasn't even addressed by opposition. Yet the court summarily dismissed that.
Counsel, I like to go back because we're talking about Mr. Lunan, but if we look at, I believe it's 412 of the record, he testified that the plaintiff's job was not to remedy anything, that he could make him aware of certain things and mention it to the tenant, but he wasn't supposed to perform any repairs or anything like that.
That's exactly what I was referring to, Judge, and my point is, his task was to be the safety person. He did not have to participate in the safety remedy. He could have alerted. In this particular case, he thought that he could handle the situation himself. But last point is, less than 10% of what he did for DF Auto was involved with auto. He was responsible for over 30 to 40 buildings, and that's in the record as well.
Okay, you'll have a couple minutes on rebuttal. Thank you very much, counsel.
Good afternoon, Your Honors. May it please the court. I represent the respondents 935 and Old Iron.
What is your name?
Kathleen Mulholland.
Thank you.
I'd just like to kind of respond to what the questions you've already raised. There seems to be some implication here that there were alterations going on in the building. There were no alterations going on in the building. The record.
They were moving out, right? M&M Auto had, I think, a day or two before vacated the premises, and there was some glass left over, and somebody was coming to take some of the glass. So and there was the removal of a truck lift, which left the wire that the plaintiff was ultimately injured by.
So the glass that we're talking about, we're not talking about like windows or pieces of a building. The company that was leaving was an auto repair glass. So it was the removal of the glass, the inventory. And on page 340 of the record, Mr. Lunan was specifically asked about construction or alteration, and he specifically said, well, no, there was no alteration going on. It was the removal of inventory.
Well, counsel, okay, at least to label law 200 and common law negligence, which might not necessarily need those specific factors, why isn't this that kind of case?
Okay, so I'll step back for 1 second. Again, if the original part of my motion started with number 1, was that the plaintiff was essentially our employee, okay? And I'll submit to you that basically during the course of argument, plaintiff essentially conceded that he was our employee of 935, of Old Iron, of all Mr. Ferravecchio's entities. But he was put there on site to take a look and see what was going on as the company was moving out, okay? The record is clear that the only one who may have had notice of anything going on in that room would have been the plaintiff. So you can't put notice on us when the person who who caused the accident was the person who had notice. Nobody else at 935 or Old Iron or anything, the record's clear. Nobody said, oh, there's a problem. Plaintiff even said, when I saw the wire.
Which is why you're saying that the common law negligence fails too, because of the notice, the lack of notice.
Exactly. I mean, the plaintiff even said, I didn't tell them. I did everything of my own accord. As was quoted, Mr. Lunan said, had we been told, we would have said, don't do that. I mean, you have to remember, the plaintiff chose.
Well, hadn't the plaintiff been told that the electricity was off? And obviously that was not the...
That is, the other respondent will address that. I believe, is going to say that her person told him.
Okay.
But it wasn't our person. We never gave them permission to put the lift in the place. We never gave permission for them to leave the lift. Mr. Lunan said, I went in and out of the site about once a month during their tenancy, and I noticed a lift, but there was no sign-off. There was no discussion. As a matter of fact, M&M specifically, their witness specifically testified, let's see, 607, 614, 615. They're the ones that hired the company that installed the lift. They're the ones that, hired any electricians that were necessary for that lift. So all of that was M&M Auto. Nothing with respect to the lift was ever placed on notice to my clients. Thank you.
Okay, thank you.
Good afternoon, Your Honors. Michelle Meiselman for Respondent M&M Auto Glass.
Do you want to just take that mic down a little bit? Do you want to take your mask off, or
Oh,
you're
yes.
comfortable?
I forgot I had it on.
It's easier for us to hear.
Thank you.
If you're comfortable with it.
Okay, so my client, M&M Auto Glass, had vacated the property approximately 5 days before this accident. Yes, they did have this auto lift installed while they were there. It was used for their business. And before they left, they had the same electrician come in and disconnect the auto lift. The auto lift itself was removed from the premises and stored somewhere else. My client was told by the electrician, the power is off, and the wires that had been to the auto lift had been capped. The wire for the auto lift ran up the ceiling and had come down to the auto lift, but it had been, once the auto lift was removed, there was only this conduit that was left hanging on the ceiling. A couple of things about the power to the auto lift. The power was by virtue of a breaker. This was a commercial property. They didn't have light switches. They had breakers. The lights were on the breakers, the auto lift was on the breakers, everything was on the breaker. My client, before they vacated the premises, 5 days before, made sure the breaker to the auto lift was off. We don't know how the auto lift breaker was turned back on. That's something that's, at least my client has no idea. It can only be speculated someone maybe switched it by accident when turning on the light. Also, again, my client hired a contractor electrician to come in and remove it because my client was not in the business of electrician, and my client was told the wires had been capped. My client said that he told plaintiff wires are capped, make sure the breaker's off, and then my client was gone. Pursuant to a stipulation with the landlord, they had to be off the premises by March 27th, and at that point in time, anything left behind by my client became the property of the landlord. My client had no control of the property at that time. There had been some speculation as to former employees on the property representing my client's possession of the property. These were former employees. There had been a lot of testimony that the person who came in to buy my client's inventory,
Freeman or something?
Freeman, hired our former employees. In fact, the man driving the forklift was a former employee of my company, my client's company, and other former employees were there. My client was not at the property. My client was not aware of any problems with the forklift. In fact, we were told by the electrician the forklift was properly removed. And as far as my client,
Was there anything in writing that reflected your arrangement
Yes.
with, the company, what was it, Jose Equipment Sales and Services that actually?
Oh, for Jose Equipment, no. It was done very informally. It was done over the phone.
Is there any dispute that they're the company that came
No.
in and removed the forklift, the lift?
No, there's no dispute at all, and I believe they don't exist anymore. They were even named as a defendant, and they can't be located. So unfortunately, we couldn't depose anyone. But there's no disputing that my client, like I said, hired somebody to do the work, was told everything was done and removed, and that was it. Everything was ceded to the landlord once we left the property.
Any questions? Okay, thank you.
Thank you.
May I just draw the court's attention to the record pages 340, 341, 841, 843, 845, 848, 1262, and 1300 and 1301. In those documents, you're going to find that there is uncontroverted evidence that on April 2 of 2015, there was ongoing construction activity on the premises. This included alteration of the premises by installation of new brick, sheetrock in the area of the accident, and the creation of additional hallways and walks within the building so as to constitute a significant physical change to the premises. It is based on that activity that this was a construction site within the purview of the labor law. Therefore, the violations of the industrial code with regard to the electrical wires pertain.
So tell me again, are there pages in the record that reflect your client's position as you've represented as the safety supervisor for the
That was his
owner?
testimony. Jonathan Lunan ran 935 and Old Iron. Okay, he was basically that part of the business. Dominic, why didn't we hear testimony from Dominic Ferravecchio? He's the owner of all of these companies.
He never testified.
Never, okay? And the reality is Anthony De Jesus was really a building guy who happened to have a little interest in cars, and Dominic wanted him to go to South Carolina and do some transporting of cars. So they ran that part of the business through Anthony. But 90% of his job was making sure that the buildings were functioning properly and safely. That was his number one job. So he was the safety manager for all, not only this property, but for all of the properties. And that is in the record. That's what Anthony De Jesus said. Also, Mr. Smith, who was working on the property at the time, confirmed that he knew Anthony De Jesus was a guy that we went to get things done in the building. So I think if we get over the fact that this was clearly a construction project, and then we look at what his tasks were, clearly he's doing tasks that are construction related, but at the very minimum, he is a person who's lawfully on the premises. And as such, he's entitled to the protection of Labor Law 241-6, Section 200, and at a minimum, where there's no opposition, common law negligence.
Okay, thank you all. We'll certainly take a look at this
Thank you, Your Honors.
again.
Thank you for your time.
Thank you. The next case for argument is Bustan versus 35 West Realty.
Good afternoon, and may it please the court. I'm Norman Flitt. At issue here is the meaning of a phrase in Article 9 of the rider to this lease, and that phrase, which I'll read in a second, has to be construed together with the provisions of Article 8 of the printed form requiring liability insurance to be in standard form. Now, the phrase, to obtain public liability coverage against claims for bodily injury or death in the amount of $2 million in a single limit or under an original policy with an umbrella. Now, $2 million is the only number specified in the insurance provisions of this lease. We need to focus on what the requirement for $2 million means.
Your client only had $1 million insurance initially, correct?
My client is the landlord, and the tenant only had $1 million occurrence coverage. They had a $2 million umbrella.
Counselor, that's the question. What does single limit mean? Does it mean per occurrence, or does it mean something else, right? And you had two experts, one saying one thing and one saying the other. But how do you address the precedent in this court, where when you have something like this in a commercial landlord-tenant context, and if there is an ambiguity, it's kind of, the precedent says, goes against the landlord if there's an ambiguity, particularly if you're going to increase the burden on the tenant. How do you address that? How do we get around that?
You get around that this way. If you agree, and I don't, that the clauses together are ambiguous, then you have, I believe, two reasonable interpretations of what is required of the tenant.
Got that. Right, you got two reasonable interpretations.
Now, when you
I got
have two reasonable...
One interpretation increases the burden on the tenant.
Right, and the other specifies $2 million in occurrence coverage. And I disagree that if you have $2 million, there's an increased burden.
Well, there's also another wrinkle. Not only that they got a $1 million per occurrence, but they got an aggregate of $2 million coverage, right? So it's not like, I would tend to agree maybe with you if their aggregate was $1 million versus $2 million. So, you know, I mean,
If the
what do you got there, right?
Okay, if you construe the $2 million as referring to the aggregate, the question becomes, what is the required amount of coverage for each occurrence? If that's unspecified, which is not a commercially reasonable conclusion to make in a commercial lease, you could have a tenant arbitrarily, for example, providing a policy with $500,000.
Why couldn't you just simply say per occurrence in the lease? It would have been simple to say that, right? Instead of using a single limit, the way it's said, which is, I've read in the record here that it's usually done in auto policies and not commercial landlord-tenant policies.
Well, let's take it in the auto policy context. The Court of Appeals said you take the single limit, i.e. the number, 500,000, here, 2 million, and you apply coverage for both property damage and bodily injury for any one accident up to that limit. Here we're saying, and it's not, believe me, this is not a perfect agreement. Maybe it's,
Okay.
Well, we'll all agree
Well,
on
I'll agree
that.
with you there.
it
You
is-
win that one.
It is an agreement that we have to work with and that can be interpreted to require $2 million in coverage within its four corners. And why?
Unless I missed your argument, I haven't heard how we get around our precedent. I must
Construing it
not
against
have
the
heard it.
landlord?
I'm sorry?
Yes.
Okay, you don't construe an unambiguous contract against the landlord.
No.
Further,
But
on a motion-
if it's ambiguous, I mean,
if it's ambiguous and you have two reasonable interpretations on a motion for summary judgment must be denied, and we deal with what the intent of the parties was at trial. Many cases, Court of Appeals, this court, have said that. Supreme Court should have stopped the analysis when it concluded, and we disagree, that this is ambiguous. Once there's that ambiguity, and what are you doing with inferences? This is a motion they have for summary judgment against the landlord, and you're
But I
construing-
mean, I know that's what you're saying, but what my colleague Judge Oing is saying, and what I also was going to say is where that's normally what I would say, yes, if a contract is ambiguous, our precedent and Court of Appeals too seems to say that if there is an ambiguity as to the meaning of a lease prepared by a landlord, the ambiguity is resolved in favor of the lessee. So that's, isn't that what you're saying? That precedent is what we're trying to figure out. How do you get over?
Well, you get over
You
if
did
I-
not agree with that, with that analysis?
I agree with the analysis if there is an ambiguity, and what's ambiguous? Is $2 million ambiguous?
Oh, so you're taking a position that the single limit is not ambiguous and it means per occurrence in the story. Okay,
Okay.
got it.
All right, let's hear from the other side. You'll have a few minutes to respond. Thank you, Mr. Flick.
Good afternoon, Your Honors, and may it please the Court. My name is James Fishman for the respondent, Booston LLC. I think Your Honors have it absolutely right. There is nothing in this lease that says per occurrence. It just doesn't exist.
Well, there's an ambiguity, and the precedent is in your favor if there's an
Exactly.
ambiguity. And when counsel says there is no ambiguity, that gets cut by the fact I got two experts who argue otherwise.
You don't even need to.
Created ambiguity right there.
Right. Well, and Justice Chan said, I don't even need the expert. The expert isn't really necessary for this resolution. I can read with my own eyes what this lease says. And the judge is supposed to do that and interpret a lease as a matter of law. That's a legal issue, which Justice Chan did. And she found that there's nothing in this lease that says per occurrence. If they wanted per occurrence, they could have
Gotta put it
said
in
per
there.
occurrence. They didn't. Now, this lease was entered in 2000. This landlord bought the building 6 years later. And for many years, my client provided exactly
Yeah,
what
but you
they
can't-
Well, of
Yeah,
course,
but
there's a
there's
no
no
waiver
waiver clause.
clause.
No, Your Honor, I'm not saying waiver, please. I'm saying what Justice Chan said, which is course of conduct. And course of conduct is a highly persuasive way of determining the intent of the parties. And that's
It's
what
another
she did.
way.
Wouldn't that be something that would be best left for trial then, at that point?
She can do it as a matter of law, Your Honor. There were 5 years of certificates of insurance provided. The landlord denies that, but there's nothing in the record to support that denial that they got those 5 years. We have an affidavit from our client that says, I gave it to them every year for 5 years. Nowhere in the record do they rebut that we didn't get them. So that's an undisputed fact that's resolved against the landlord. And Justice Chan correctly said, 5 years of sending in these COIs, which say 1 million per occurrence and 2 million aggregate, that's a course of conduct which establishes what the intent of the parties was. Because obviously, if that wasn't the intent, and I'm not talking waiver, if that wasn't the intent of the parties, then what was it? And she is perfectly, properly examining this course of conduct evidence, which again was unrebutted, to find this is how these parties chose to proceed. Now, 1 year before they issued the notice to cure in 2018, the landlord writes to my client and says, we need the COI. Client, same day, sends it to him. Next day, gets an email that says, okay, we'll review it and advise you accordingly. Then about a year later, they bring a notice to cure saying, you don't have the right insurance. That's it. So if that's not course of conduct, I don't know what is. And Justice Chan correctly found that it was. If the landlord had something to say about it, they could have said it, they didn't. So, and as the cases that Justice Chan cited in her decision, course of conduct is a highly persuasive way of interpreting the intent of the parties when there is a possible ambiguity. And she did that. There is no reason to change anything that Justice Chan did in this case. She properly granted summary judgment to the tenant, and it should be affirmed. And if Your Honors have any other questions?
I think not. Thank you very much, counsel.
Thank you, Your Honors.
First of all, there's no course of conduct that was unequivocally established as a matter of law based on this record. They had allegations of waiver and
Hold on,
receipt.
counsel, what did you put, because your adversary is saying that it wasn't, you never addressed the course of conduct, the 5 years of the COIs, and what did you put in the record, if you could just direct us to that?
We categorically denied in our response to the 19A statement each of their supposed allegations of waiver. Record 240 to
Well, he's saying it's not,
242.
we're not talking about waiver here, we're talking about the course of conduct. Is there a difference, or is that a
Right,
without
right.
distinction?
If we never got the certificates and we never said anything about it, we had nothing to base a course of conduct on. And we served a notice to cure, and one of the elements was we never got the proof. We never got the proof. That was part of the notice to cure. It was in our client's affidavit, incorporated by reference. We first got
But
the certificate.
he indicates that the day after he was asked for it, they sent the proof of the insurance contract, and you respond, not you, but someone on behalf of your client responded and said, okay, we'll take a look at it, thank you.
Get back to you.
So that, yeah, so we'll get
Right,
back.
that
to
was in September 2018.
Right.
Within that same insurance period, our response was to serve the notice to cure. And
10 months later, right.
September 18 to March, whenever we served the notice to cure, I believe.
It was 10 months, counsel, according to the record.
Now, the other thing, and I didn't get a chance to address this, is how can you dismiss my second and third counterclaims? I had a claim for use and occupancy, both in arrears at fair market value and accruing. I got 100%.
But I thought that the record reflects that there is no arrears in the rent, and that they've agreed to pay continued use and occupancy monthly.
At least value. We claimed at fair value. There's no agreed upon number, so they could be paying more, or we could be getting more. And the other thing is attorney's fees. If I prevail on getting my arrears, why dismiss my claim for attorney's
But there
fees?
are, I thought, again, am I not correct in looking at the record that there were no arrears? So what arrears are you gonna get?
We got $680,000 or something like that, over $600,000.
Because they've been paying you.
No, we had to collect that. We made a motion. The decision is part of the record properly. And what else? Standard form insurance, which is required under Article 8, gives you all the information you need on per occurrence and what is required, and it clears up any ambiguity. And if you look at that, if you look at the standard form policy and what triggers coverage, i.e., an occurrence, there is nothing ambiguous about the $2 million. You need $2 million for an incident. Single limit means per accident, substitute per
Okay.
occurrence, and you've got it.
Okay, counsel, we will certainly take a look at all those things. Thank you both very much for your time.
Thank you.
Tower 570 versus Miller and Rubel.
Good afternoon, Your Honor, and may it please the court. My name is Jesse Loeffler. I represent Tower 570 Company LP, the landlord in this case. This is a case that involves a commercial landlord, my client, and a tenant who vacated early, leaving approximately $700,000 in unpaid rent. Discovery has demonstrated that the principals for shareholders of that tenant entity, after making the decision to quote-unquote wind down the entity without following their own shareholders agreement or New York law on how you dissolve a corporation, which involves paying your creditors first, they took, and I'm not going to use exact numbers right now because it was filed under seal, but the amount they took after making that decision could have paid landlord's judgment many times over. None of that is in dispute. Those facts exist. What is in dispute is whether an exculpation provision that had express limitations in it could be interpreted to ignore those limitations and insulate principals from willfully taking all of tenants' assets. The trial court ignored that language of limitations in its interpretation of this provision. And I'll say also it ignored tenants' counsel, which when deposed also rejected the trial court's interpretation. And tenants' counsel was the sole drafter of this provision, paragraph 48. Now, I'll get into it in a moment. The way that the trial court rejected even looking at tenants' counsel.
Wait a minute. When you're saying tenants' counsel drafted that exculpatory clause, your client signed it. I mean, it clearly, unless I'm reading a different exculpatory clause, unless the distributions are out of or extraordinary and not in the regular course of business, you can't go after the individual partners personally. They're off the hook. And you can't also use any of the defenses or claims that a creditor could have in bankruptcy court. It's pretty locked down in terms of what you can go after.
It is a very broad provision, and what I'm saying,
yeah, it's really broad.
And what I'm saying is that the trial court ignored the final 6 words of sentence 2 of paragraph 48, which you're referring to, the consistent with tenants' customary past practices.
Yeah, and they put up their financial guys for whatever affidavits, or did you not have a chance to depose the financial people, or it was all purely affidavits, right? I don't remember.
There were numerous depositions in this case.
And what transpired in those depositions? Did you prove them wrong?
Yes, I believe we did. And
okay.
Here's what so tenants' counsel drafted paragraph 48. He testified that it was not intended to be an absolute bar, that DCL claims, like the ones we brought, for...
I'm more interested in the financial guys in terms of their testimony, because I didn't see it or highlight it in terms of what their testimony was in terms of how the monies were paid out, and that it was extraordinary or not in the ordinary course of this prior distributions. I didn't, unless I overlooked it, I didn't see that anywhere in the record, or at least the arguments.
I think you're referring to the financial experts we put on. Yes. So the trial judge didn't address that at all. And we put that information in.
Yeah, but I could look at it, though.
Pardon me?
I said I could look at it, though. Right?
Yeah,
Even
so
though the trial judge didn't address it.
Sure. So record pages 315 to 316 is our expert. Disputed by their expert, record pages 444 through 447. And essentially, when we looked at these distributions, and this was in the context of, actually, our expert, Mr. Polanski, I was before this court last year, where Mr. Polanski's expert credentials were called into question, and this court approved of his...
Not this bench.
Half of you.
Half of us. Oh, I don't remember that.
So the trial court didn't address that, but we put on evidence which, if there's a dispute between these financial experts, it's a matter for trial, not for resolving a summary judgment.
Counsel, let me just ask this question in terms of, I guess, any insolvency. The tenant was paying the use and occupancy or the rent, whatever it may be, up until September 2018, right? And so even during the wind down period, they weren't necessarily insolvent. They were paying their rent. What else is there?
So the trial court also didn't reach the insolvency analysis, and our experts in the record pages I just cited addressed this issue too. Interestingly, half of this bench approved of Mr. Polanski's solvency analysis in 140 West 57th Street Building 205 AD 3D 401. The trial court didn't address that, and the issue was they had sucked literally every asset out of this entity, rendering tenant a judgment-proof entity, except for the rent they paid through the end of August, through September. Insolvency is based on what the liabilities are. They still had $700,000 of liability to my client, to landlord, under the lease. And so to the extent they've now sucked all the assets out of this entity, and this was proved in discovery, there's nothing left in tenant, then by definition, the tenant entity is insolvent. Again, the trial court didn't actually do that analysis, didn't do that insolvency analysis in connection with its fair consideration statement. The trial court made literally one sentence to say, well, even if paragraph 48 didn't have these words of limitation at the end, then it was for fair consideration. But these are transfers to insiders, which lack good faith under well-established New York law, including the case I just cited, 140 West 57th Building. I see my time has come.
Counsel, but I do have a question, because I want to go back to those 6 words, right? Consistent with tenants' customary past practice, because you take the position that that is limiting languages. Am I correct about that?
That's correct, and that's what the tenants' council testified.
Well, but I want to stay on this, because how do you address the fact that in this same sentence, it says, in furtherance of the foregoing, and we know in furtherance of the foregoing, right? The language is very broad. It is clear. It's unequivocal that you cannot sue the principal. So how do you address that? In furtherance of the foregoing, when, you can't sue the principals.
Tenants' council addressed that as well. In record page 205 to 206, as well as record page 198 to 199, where it doesn't mean just because in furtherance of the foregoing starts that sentence that the words of limitation at the end, you don't read them. Tenants' council testify that sentence 1 means no liability under the lease. Sentence 2 means also no liability under bankruptcy or debtor-creditor law, only insofar as it's consistent with tenants' past.
Yeah, but isn't that like extrinsic evidence? I mean, why is that even important? Because to me, paragraph 48, it's clear. What's the ambiguity in paragraph 48?
The scope of paragraph 48 was ambiguous with how the 2 sentences interplay, and Judge Cohen, who was previously on this case, made a finding of ambiguity, which we argue is
Oh, no, he didn't. That was a motion to dismiss. That was a motion to dismiss, and he found that the complaint, assuming the allegations were true, he made no finding that there was ambiguity. So
he expressly
I saw that
says
argument.
it's ambiguous and we cited in the
okay.
case. And then in reliance on that, we went into discovery. If he would have found it unambiguous and as broad as the tenant has said, we wouldn't have gone through 2.5 years of contentious discovery, including depots of the drafters of this.
Okay, you'll have a couple minutes on rebuttal, okay? Thank you very much.
Good afternoon, Your Honors. May it please the Court, Stephen Lester, Garden City, New York, for the respondents. The court below got it right when it observed that this lawsuit appears to be plaintiff's attempt at an...
Counsel,
Yes.
let's just start here. So yes, there's this limited language at the end of paragraph 48, consistent with the tenant's customary past practices. Some of the things that went on here weren't necessarily things that you would find in every certain transfers, certain purchases, payments to insurance carriers. I mean, how do you explain that?
Well, the second sentence doesn't even apply here because of the beginning of the second sentence. It says that in furtherance of the foregoing, the owner, which is the appellant, shall not have or benefit from any claim available to any creditor or trustee seeking any recovery from any tenant. In other words, this was...
To such tenant exculpated party consistent with the tenant's customary past practice. I mean, it's a complete sentence.
Right, and the bottom line is that it's meant to apply only to the landlord attempting to piggyback onto the claim by a trustee in bankruptcy or some other creditor. The first sentence is an absolute complete waiver by the landlord of all liability for the individual respondents. That clause, the first sentence, is broad and unequivocal. And then again, as the court noted, the second sentence starts out in furtherance of the foregoing. So it is not a limitation on that first sentence, but an additional waiver.
But notwithstanding that broad paragraph 48, would the individual defendants be responsible for active wrongdoing?
And
And is that something that we should be evaluating, active wrongdoing?
the court doesn't need to reach that question because there was absolutely no evidence of active wrongdoing.
So, I mean, they hired certain people to advise them about their winding down procedures and whatever.
Correct.
It's, their claim, there was some claim, I think, that might have been not usually done in winding down a law firm because they were all going somewhere else, and why did they need to pay so much money to whoever that company was?
The law firm paid the employees, including the individual respondents, as they had the same way for 40-plus years. This is an unusual situation because this law firm was a C corporation. So in order to avoid double taxation, they paid the...
Right, they paid out, they made all the distributions, and then the partners will loan money back to the firm to pay their expenses so that they have a loan at that point.
So that they would have sufficient cash flow to meet their expenses.
Right.
After they zeroed out the net income for the firm. And again, this was all done because they are a C corporation. And again, the individual respondents and the tenant paid them the same way that they had for 40-plus years. There was nothing different done. One or two of the mechanisms were slightly different, but the economic effect of everything was exactly what they had done. And
In other words, so that with respect to these transactions that may have been sort of like questionable, we always zeroed out at every end of the year. We zeroed out. I mean, that's how we always did or ran our business. We zeroed out, and then the partners would put money back in by way of loan, then we pay it. But the fact that some of these payouts may have been questionable or anything, it's not out of the ordinary that we zeroed out at the end of the year.
Correct.
We had zero sums.
correct, and again, the fiscal year prior to the tenant vacating was the tenant's law firm's worst year. And so the numbers in absolute terms seem different from fiscal year 2017 to fiscal year 2018. But then in context with the fiscal years 2015 and 16, which were not requested in the discovery by the plaintiff, the numbers were normal. But regardless, the procedure that the tenant followed was the same year after year, and it had been for decades. Also, the law firm and the individual employees earned all of the revenue of the tenant. Again, the employees' time and advice were their stock and trade. A law firm is not an entity that has hundreds of thousands of dollars in inventory. It doesn't have a fleet of trucks. It doesn't have manufacturing equipment. The individual employees generated all of the revenue, and the net income was paid to the employee shareholders as W-2 salary, which taxes were paid.
Why you had that exculpatory clause put into the lease.
Precisely. And again,
Because of the way you set up your S corporation, you wanted to make sure that if something happened, the individual partners wouldn't be personally liable because of the way you structured your transactions or the distributions.
That is exactly correct. And also, there was evidence in the record that the employee shareholders were at a certain age and they were considering retiring, and so they were, or at the end of the lease term, they would be possibly considering retiring. So again, they were very concerned about personal liability, and that's why paragraph 48 is in there. Otherwise, paragraph 48 would have no meaning, because the individual respondents could not be sued on the lease because they're not parties to the lease. So if we adopt the landlord's theory, paragraph 48 is in effect a nullity, because the only way that they could be sued is on common law and statutory claims.
Okay,
Thank you, Your Honors.
thank you. Counselor, you have 2 minutes.
Thank you, Your Honors.
You know, I couldn't understand why this exculpatory clause existed, because it was really unusual. I've never seen anything like it until I've heard your colleague, the position here is that the way we treat the distribution, we knew going in that this is how we had to protect ourselves because we zeroed out every year.
So Mr. Last, tenants counsel, testifies to this. He used it in prior law firm representations, and consistent with customary tenants' past practices, designed to, if you're running your operation in like the ordinary course, you're making distributions to partners.
Well, zeroing out at the end of the
They're
year.
protected.
Yeah.
Okay, so it's separate. If we were looking at this separately, we think there's a fundamental difference as a whole, even with respect to the salary distributions, if you've made the decision to wind down an operating.
No, but going back to the point about how, was it unusual that they zeroed out? It doesn't sound like they did, that it was. I mean, even if they had some distribution of payouts that were sort of like, you could question whether or not they were valid or whether or not they were legitimate, at the end, it was no different than how they operated their businesses in prior years, where everything was zeroed out and the partners would lend money back to the firm to pay, the rent.
Right, so putting aside the salary piece, which our expert, which we cited earlier.
Did your expert say that that was wrong?
Yes, he talks about that. He says there was a 20% increase in fee income, which is their only income, yet a nearly 100% increase in distributions in the final year. I just want to make the point, outside the salary, there were a number of unusual transactions. You point out.
I point out, yeah.
Right, that we think even if you separate the salary piece, there's tons of these
Did
other
your experts say,
transactions that are
I don't
not.
recall, but did your experts say that the process of the procedural protocols that they employed as an accounting situation was wrong, flat out illegal and flat out wrong? You
Like
can't
he says it was illegal. He calls into question this idea of whether you have to distribute every 6 months because double taxation only happens at the end of the calendar year. So the June 2018 distributions, when they're already working at another firm, was not necessary for tax purposes. There's hundreds of thousands of these other transactions that never occurred except in this final year. And so you can take those separately and say, well, this certainly can't be consistent with tenants' customary past practice because you had this loan process that you now aren't doing anymore, because you're surrendering key man insurance policies that have a purpose of paying out for a deceased shareholder's shares in the event that the firm is still operating. Yet they're releasing these insurance policies that are worth nearly half of the outstanding liability. They've never done that before, so it certainly can't be consistent with tenants' customary past practices.
Okay, we'll take a further look. Thank you, counsel. Thank you both.
Thank you, Your Honors.
Francis versus 3475 Third Avenue.
May it please the court, Your Honors. My name's Alan Friedman, and I represent the plaintiff appellant in this matter. Basically, Your Honors, the lower court, the trial court, made two fundamental errors in this case. One factual, one legal. I'll start with the legal first. The legal was that the court found that the defendant's actions was a proximate cause of plaintiff appellant's accident under Labor Law 240 subsection 1. After that,
And then apply the recalcitrant worker / sole proximate cause analysis after you made the finding that the defendants were the proximate cause of plaintiff's injury, right? Is that where you're headed?
I'm sorry, Your Honor, I didn't hear that.
Your position is that the Supreme Court below found that defendants, whatever happened, was a proximate cause of. You're the plaintiff, right?
I'm the plaintiff.
Okay, I just want to make sure. Got the right person.
Let's get that right.
So your position is that once that finding was made, that was it. But then the court went on and said there's a factual issue as to whether or not your client was the sole proximate cause / recalcitrant worker. And you're saying that's not what the precedent says, right?
100% correct, Your Honor.
We don't get there. If we make the first finding, we don't get to the second one.
You don't, exactly. It's like on a jury sheet, Your Honor. You make that finding and then you.
You answer yes, do not go on to the next question.
Oh, do I miss
Your
those
Honor.
days?
Remember those?
Yes.
Just
So, if I can just go on. Now with a motive.
Sorry, I took your argument away from you.
No, I appreciate the help, Your Honor. Now with a motive caution, Your Honor, just to go forward. Now, there's also factual errors in the record, okay, if I can. or factual, well, I
Is
do want to
that,
add,
are you pointing to the part of the court's order where he talks about Mr. Vickelou's testimony, where he says that Mr. Vickelou provided these items to plaintiff, and in fact, in the testimony, he actually wavers and says he doesn't recall towards the end, right? I mean, isn't that grounds enough for us to reverse the trial court?
100%, Your Honor. In fact, I'll go further than that. He said he provided him with nothing. Okay?
Well, he said
What
he
he said
couldn't
was he didn't
recall.
remember if he was wearing anything when he was on the scaffolds. Okay? But he actually said, it's clear in the record, he didn't provide him with anything that day at all. And that was in response to defendants, you know, there was a third-party defendant, they asked him that question as well. So, also, Daniel Rad, who testified on behalf of the GC and the owner, he said he didn't provide anything to the contractor, any equipment to the contractors as well. Said that a number of times. And a plaintiff appellant was an employee of a subcontractor. So that's a factual error as well. Now, 241.6 also, the court said there's an issue of facts as well, but Daniel Rad testified that the planks weren't tied down. So, and if that's in the record too, I can point to the.
I mean, they were standing on this outrigger scaffold, right?
Yes.
And the two of them were carrying some kind of decorative tile that weighed about 40 pounds, and they both fell.
It's like a teeter-totter, Your Honor.
You know, they fell off. I mean, how could that not be 240? They're on a scaffold that the planks fall off of.
I agree with you, Your Honor.
How is that not 240 subsection 1? It seems like that's, you know, classic.
I agree with you, and I rest. I'll reserve my time for.
Response, okay. Fair enough.
Good afternoon, Your Honors. Kelsey Doherty Howard of Gartner Bloom, for the defendant respondents. First, I would like to.
Which defendant are you?
We are all the defendants.
Oh, the defendants, okay.
Yeah.
Good.
I would first like to submit that the lower court did not fully find that the defendants were the proximate cause of the plaintiff's accident. In fact, the issue is the plaintiff was given safety devices. He was given a harness.
Isn't that a question? I mean, really, isn't that a question? Whether who was he given safety harnesses by?
Sure, and I believe that question is answered by the testimony of the plaintiff.
Hold on 1 second. The court below says, this court finds plaintiff made a prima facie showing of Labor Law 240 Subdivision 1 violation, as it was undisputed his injuries resulted from the collapse of the pipe scaffold. However, defendants in Ideal raised tribal issue of facts of whether plaintiff was the sole proximate cause of the accident. So the court did make a finding that there was a sole proximate, that plaintiff made out a sole proximate cause, that the defendants were the sole proximate cause of the accident.
I do not believe so, Your Honor, as the finding.
Okay. How do you read that then?
Well, the ruling says that the plaintiff, there's a question of fact as to if the plaintiff himself was the sole proximate cause.
That's right,
of the
but but the first part is that he got the discussion that we had was that once, as Justice Kapnick pointed out, once you make a proximate cause finding, which the Supreme Court arguably did, that's it. You don't go and then to start deciding whether or not there was sole proximate cause of the accident, because it's sort of inconsistent at that point, because once you found something that's a proximate cause, you can't turn around and say, well, the plaintiff was the sole proximate cause.
However, Your Honor, it is well established that if an adequate safety device is provided to a worker.
Well, I'm sorry to interrupt you, but
go ahead.
I really think that that's a question.
Of course.
Because Mr. Vilaku seemed to have contradictory testimony throughout the course of his deposition. So at one point, he testified that he was not wearing a harness at the time of the accident, and he did not give plaintiff any safety equipment. Later, he says he did not know and he could not recall if plaintiff was using a harness or a lifeline at the time of the accident. The plaintiff said there was no lifeline and he wasn't wearing a harness. So I think it's very unclear as to whether or not they provided him the proper protective equipment at the time of the accident.
And then just to add to that, they both fell to the ground, right?
Correct. Yes. Yes, but if I could
Which would
point-
imply there was not a proper safety device.
Well, if the proper safety device was provided and not in use, I believe is the actual question. So if I can point the court to the record of 1165, Mr. Verlaku testifies that he did, in fact, provide the workers of Ideal with harnesses and lifelines, and that the plaintiff himself, in his testimony, touts that he has nearly 20 years of experience in this type of work, and he was aware that a harness and a lifeline should be used.
Did he say he was wearing one?
No, he said he was not provided with one. However, that is contradicted, as the lower court notes, by the testimony of Mr. Verlaku, who said that there were adequate harnesses and adequate lifelines provided to all Ideal employees who needed them. And if the plaintiff had these safety devices, which we believe he did, and he chose not to use them, that makes the plaintiff the sole proximate cause of his accident under 241 and 241-6. So it is respectfully submitted that this court honor the lower court's decision and find that the plaintiff was the sole proximate cause of this accident. Unless there's any further questions.
No, thank you.
Thank you.
Third-party defendant?
Breathe for a moment, if you don't mind. May it please the court, Glenn Kaminsky with the firm Omni Demers McManus, counsel for the third-party defendant, respondent Ideal Masonry. The court order below is internally inconsistent. You can't say that there was a prima facie case and then say there's a sole proximate cause. The court recognizes this. I can't tell you the number of times I've been in this room and had bench or bar talk about two proximate causes, or that there can be multiple proximate causes. And that's got to be half the time or half as many times as you've heard it. But I'm talking here today about there being one proximate cause, and that proximate cause that the jury can decide is the failure to use available safety devices. And yes, Your Honor, there is not great testimony for Mr. Verlaku. It's true. He's not the greatest witness in the world. But that's not what we do here. He does say, I provided it. He does say it. And when he's responding to driving the plaintiff to work and asking questions about driving the plaintiff to work, and then plaintiff's counsel slips in an answer, oh, what equipment did you provide him? Well, I would answer the same way.
So are we wrong that on a Labor Law 240 subsection 1 claim, if there is a finding of a statutory violation of a defective scaffold, that was a proximate cause of the accident, the plaintiff cannot avail themselves of the recalcitrant worker defense? So if we find that there was a statutory violation, which if they're standing on the scaffold, and I looked at the pictures and I read the testimony, and the planks fell off and the two guys fall down, how is that the plaintiff is the sole proximate cause of that? We don't get to that question on a 241 claim.
And I'm going to say respectfully, I disagree. And I refer you to the Giordano case that the court below Justice Suarez referred to at page 8 of the record, a case you were on, Your Honor, where the plaintiff steps on a pipe of the scaffold that collapses and he falls. And they don't find 240, they find an issue of fact because of sole proximate cause, because the plaintiff could have been using a double lanyard and wasn't. Giordano, page 8 of the record, 2017, this court. What I'm trying to say here is because of the nature of the lanyard and lifeline system, right, which prohibits you from falling. If you've ever worn one, I've had the luxury of doing it. It keeps you from falling. A jury can say, you know what, this thing fell away. The outrigger collapsed. But the only reason this guy got injured is because he didn't use the available lanyard that he could have had. And that is a reasonable interpretation. And proximate cause is generally a jury question The jury should get to hear that. That is all we're saying here, Your Honor. Let 6 people in a box make a decision. Any other questions?
I think not. Okay, thank you.
Thank you.
Your Honors, my colleagues, I appreciate their arguments, especially the third-party defendant, but he keeps saying the only cause was the plaintiff not wearing a lanyard. There was no lanyard provided. My adversaries keep saying, Rakib said he provided equipment. He never provided equipment. He specifically said, well, I'm not going to go there. The court's right. Once you establish 240, the scaffolding collapsed. Period. It's over.
Well, there was a 2019 case called Mora versus White and Kent Realty, in which we said if there was a violation of the statute that proximately caused the accident, plaintiff's failure to tie off his harness could not have been the sole proximate cause. We just don't get to it. So I know Giordano was before that, but in 2019 we seem to have said that. So I haven't looked at Giordano today. I'll go look at it.
I would like to address that if I could, Your Honor, Giordano.
Yes.
I'm glad you brought that up. First of all, I have Mora right here. And Mora is interesting because Mora was decided by Judge Suarez, who decided this case, and this case is inconsistent with Judge Suarez's Mora decision. Now, Giordano, my colleague, my adversary, said the scaffolding collapsed. It didn't collapse. It was a one-page decision written by this court. I actually went back and read the record, the initial decision, summary judgment decision. What happened was, the question of fact in that case was, initially the lower court decided in favor of the plaintiff. There's a re-argument. Then the court, which doesn't happen often, reverses decision. And what happened is in Giordano, the lower court found there was an issue of fact where the plaintiff, in that case, was actually building a scaffold or not. And then he was going to connect it to a shoring system. And he was standing on a if I could just finish my point. There was a question, then what happened was it was a brace. And the brace, for whatever reasons, he fell off the brace. There was Giordano, for some reason, they used the word collapse in Giordano, but that's not what happened. I don't know why the appellate division used the word collapse, but if you read the lower court's decision, summary judgment decision, which I did in preparation for today, that scaffolding did not collapse. And again, as this court said during this argument, once Judge Suarez decided that the scaffolding collapsed and plaintiff met its prima facie case, entitlement to summary judgment under Labor Law 241, that's the end of the discussion. We just go on to damages.
Okay, I think we got everybody's points. Thank you very much. Have a good afternoon. The next case is Saporito versus Branda.
Your Honors, if I may, I have my phone. It's on Do Not Disturb, but I do use it as a tablet.
Okay.
Thank you. Good afternoon, Your Honors. May it please the court. Stephen Saporito for the plaintiff appellate, Stephen Saporito. Excuse me. Your Honor, this involves a claim under Judiciary Law 4087. I believe the lower court erred. Quite frankly, I had to read its decision about 3 times before I could figure out why the 115-paragraph allegation, 15-page complaint was dismissed for apparently failure to state a cause of action. I respectfully submit I pleaded all the elements required by the statute and case law to at least withstand a 3211A7 motion. And I'm going to repeat Judiciary Law 487. An attorney or counsel who, 1, is guilty of any deceit or collusion or consents to any deceit or collusion with intent to deceive the court or in any party, or 2, willfully delays his client's suit with a view towards his own gain, or willfully, you know what, let's skip 2, it doesn't apply, is guilty of a misdemeanor, and in addition to the punishment prescribed therefore by the penal law, he forfeits to the party injured treble damages to be recovered in a civil action. You know, my defendant has gone to great lengths to cloud a record with a 3-inch record of family court proceedings that are completely irrelevant to this action because Justice Hagler says this is not res judicata. So the only relevancy of the family court action is that that is the proceeding in which the deceit and collusion occurred. While the defendant likes to portray this as some frivolous lawsuit by a pro se attorney, nothing could be further from the truth. This is a very serious lawsuit with very serious allegations, and I would not have brought such a lawsuit had I not been confident that I could prove the allegations of the complaint. Your Honor, in full disclosure, this is my first day. Okay, I haven't been before the appellate division before. And as one of my professors had once taught me, I pretty much shot my wad in my papers. So at this point, I would like to entertain questions from the bench if the bench has any questions.
Does anyone have any questions?
Okay.
Why don't we hear from your adversary, and then perhaps that would be, you can respond to anything that he says, okay?
Thank you.
Okay, thank you. We have looked at your papers.
Good afternoon, Your Honors. May it please the Court, my name is Robert Spolzino, and I represent the respondent. This complaint doesn't state a cause of action either under Judiciary Law 487 or for fraud. There's not even a material misstatement here. If you look at Mr. Saporito's brief on page 9, the statement he asserts is the fraudulent statement, deceitful statement is, in response to the question from Judge Perry, all right, what's the other reason? He says, Ms. Branda says, she's available while she's not working to have the child on this schedule. There's nothing deceitful or incorrect about that. But that's not the only reason why this complaint doesn't state a cause of action. First of all, there's only one statement that's alleged to have been the basis for this claim, and your precedent establishes that there has to be a course of conduct, that one statement does not do it. The second point is that there has to be some injury flowing from the allegedly deceitful statement. Something has to have happened as a result of that. And nothing happened here. This was
The family court judge continued that same schedule even after the judge learned that the mother was in fact working. Is that correct?
That's correct, Your Honor. This is a temporary custody situation. Right. The alleged misstatement was on August 6th of 2014.
That she wasn't working, his allegations that she was in fact working for your client.
The matter came back on September 14th with new counsel for Ms. Ward, and the judge continued the order. In fact, the order continued throughout the proceedings until Mr. Saporito ultimately defaulted and resulted in the exact same order. So there was no injury, if you will, here. The third reason is that there was, this is not the remedy for Mr. Saporito. He should have gone back to the family court to try to vacate the decision on this basis once he knew about it. never did that. So he has no right to seek relief under Judiciary Law 487, and there are no damages here. The only damages he asserts in his complaint are that he suffered legal fees. Now, he doesn't specify, and I would submit that the entire complaint is so conclusory that you should affirm the dismissal on that basis alone. But with regard to damages specifically, he says generally and conclusively there are legal fees. But there weren't any legal fees. The September hearing was already scheduled. It wasn't a situation where he had to bring a separate proceeding or make a new motion or do anything to address. Of course, he didn't address it at all, ever in the family court proceeding. But in this case, there were no legal fees incurred for this. Everybody was back in September anyway, so there was no damage. If the court has no further questions, I have nothing else to add. Thank you, Your Honors.
Okay, thank you. We'll hear from your adversary if you'd like to respond to anything Mr. Spalzino said.
Sorry, I can't read my own handwriting. Your Honor, it appears that counsel hasn't fully read the record. My fraud claim was withdrawn. This is purely a 487 claim. And the essence of 487, and this court and the Court of Appeals and my papers have gone through extensively its 500-year-old history. The essence of a 487 claim is not to award me money, but to promote an attorney's truth-seeking function and the administration of justice. Now, I would submit to this court, when an attorney in a child custody proceeding in the family court goes before the court and represents to the court on behalf of a 3-year-old child, judge, change the schedule, mom's available to be with the kid because she's not working, and mom is working with the attorney on that date. That is egregious. That is something that we cannot allow this system to permeate, that undermines the basic fundamentals of justice and truth-seeking. It is a fraud. It was a lie. It was a lie by a prominent attorney who knows better in open court. Regardless, win, lose, or draw on my damages, my complaint is a verified complaint. It is an affidavit under oath that meets all the requirements of a grievance committee complaint. Regardless, win, lose, or draw on my 47. My complaint is an affidavit that meets all the requirements of an accusatory instrument. Let me just finish this, please. This court, and I'm not telling the court what it has to do, but I can't see how this court, as the ultimate arbiter of the administration of justice, it has to send this complaint over to the grievance committee. It has to send it over to the district attorney's office. You have a sworn statement that suffices as both a complaint and an accusatory instrument. The court has to carry out its mandate to administer justice.
Okay, thank you. Thank you both very much. We'll certainly look at the papers carefully. You too. Zucker Real Estate versus Old Republic.
Good afternoon, Your Honors. If it please the court, my name is Charles Cuneo. I represent the appellant Zucker Real Estate Corp. The appellant is a real estate investor. Quite often, it finds its deals exactly as it found this particular deal, which was by locating a property in which record title was still in the name of somebody who was deceased. When that happens, what they will do is they will try to find the heirs and then purchase the property from those heirs who inherited by operation of law immediately upon the person's death. That's what happened here.
Counsel, can you just address the EBT of Andrew Wenzel, where he indicates that he was aware of Mr.
Your Honor, I'm sorry, I did not understand the question.
The EBT of Andrew Wenzel, right? There was a deposition, and he testified that he was aware of Mr. Milton through his accurate search. How does that?
He was aware that he was occupying the premises. It was never said that he was an owner, that we did not believe that. They believed and knew he was, not believed, they knew he was occupying the premises. But as incredible as it may seem, that is not an unusual situation in real estate in New York, especially when somebody dies and the heirs don't know that they're entitled to.
So the thing is, if that's not unusual, they put into the policy that there's an exception for people in possession and the property. So how does Mr. Milton not fall into the exception, which would prevent you from getting any coverage from them?
In this particular case, that exception does not apply.
Why is that?
It does not apply because it was a general exception, and the law is fairly clear on this issue. When the person is in the chain of title, the person is identified in the chain of title, that a general exclusion in the policy does not apply. You need a specific exception for that particular person. And Mr. Wilson...
Well, the thing was he actually in the chain of title?
Yes, he was, because there was a mortgage that he had given to Susie Foote when he purchased the property from her. And that mortgage appears on ACRIS, a copy...
But it was in the wrong place for like 50 years, right?
No, the mortgage is right in the...
But how would you know to look for that if you were looking up the line of ownership of this property?
When you look at ACRIS, it says right on it, Susie Foote mortgagee, and Milton Wilson mortgagor. So admittedly, his deed wasn't there.
Right.
But the mortgage was. And
I'm glad you said that, because I was under the impression that a mortgage doesn't create title. I mean, there's case law on that. You know, isn't a mortgage, it creates a security interest, but it's the deed, right?
Well, I think that the issue is, does Milton Wilson appear in the chain of title? And according to the Court of Appeals, the chain of title includes mortgages. They've held that in the case that I've cited in my brief. So Milton Wilson does appear in the chain of title. Again, his deed's not there, but the job of the title company is to examine title, and they have to do their job in that. And if Milton Wilson shows up as his mortgage there, somebody needs to go, there's an issue here that there's a man who is granted a security interest in a property, which must mean he owns it. And in fact, the mortgage that is of record, that is on ACRIS, that was in the public record, indicates where Milton Wilson's certified title, his title to the property.
Well, to bootstrap on...
I'm sorry?
Just to piggyback on Justice Kennedy's position here, the aha moment that you just mentioned about how the mortgage is there and admittedly the deed's not, you would have a better argument. I think your argument would be more persuasive if Milton Williams or if Milton, I forget his name.
Wilson, yeah.
If Mr. Wilson was not physically on the property and there was no possession, then you would have an argument. Then there would be a better argument that says, okay, the aha moment is perfect. But in this case, he's there, so that kind of grabs in that exculpatory language.
100% he was there. And if there was nothing in the
Right,
chain...
I hear what you're saying. You're saying, yeah, he's there, I agree, but the fact is there's a mortgage there, so that takes it out of the exculpatory language, right?
It takes it out of the exception to the policy, 100%.
No question there, but I'm just saying that because the mortgage, as my colleague was saying, is very different from the deed, that's sort of a little bit of a wrinkle there, correct?
I don't think it's really a wrinkle. I think if the Court of Appeals has held that the mortgage is part of the chain of title...
Yeah, but the Court of Appeals, that case, if I recall, there was no possession in that case, was there? Yes or no?
100%, that's correct.
No possession, got it.
That's correct.
Okay.
However.
Yeah, I read the
that
cases too.
But because it is in the chain of title, that the general exception does not apply to this case. It's the specific.
You would have us, if we were to agree with you, you would have us expand the scope of chain of title to now include mortgages, irrespective of whether or not there's someone in possession of the property. You know what kind of, that would be very expansive in terms of what you're asking us to do. You're telling us that, so what if someone's there? If someone's there, it doesn't matter. They don't get that exclusion because there's a mortgage now that's listed. Whereas we know mortgages and deeds have very different concept of meanings in real property. So if I were to agree with you, we would be expanding and pretty much eliminating the exception that the title company has in their contract. So it doesn't matter anymore. As long as there's a mortgage, it doesn't matter if someone's possessing it. You got to give me coverage. End of story.
Okay, you have a few minutes to think about that and reply after we hear from your adversary. Thank you.
Good afternoon, Your Honors. David Fiveson for the title company. I think you have it right, and the case on point is the Herbal case, which is cited.
That's the second department case?
And there's a first department case that followed it. And that case says that if you're in possession, but the right that you're asserting, i.e. title, is otherwise in the chain of title, the exclusion doesn't apply. And the reason behind that is because it's my obligation as a title underwriter to review what's recorded. You buy it, it's your obligation to go out there and see who's living there.
Apparently, nobody ever does that, is what I've learned.
Well, they didn't go
reading
out.
this case.
And so the point being, Judge Oing, the right which Mr. Wilson was asserting, i.e. a fee title deed.
Not based on the mortgage.
Not in the chain of title.
Yeah, not based on the mortgage.
Correct. Now, that mortgage was a '78 mortgage for $2,000, which could have been as an ancient mortgage. And by the way, they only go back 40 years.
No, but the argument that your adversary is raising is pretty expansive. It's pretty much, it eliminates the clause that you have in your title contract.
It's not the law. And the reason why we have this clause is because the title company doesn't go out there and inspect, and who's there is their adverse possession.
I can't get over the fact that nobody goes out and looks at it.
But Judge, I have even, the lower court did not address the second basis to dismiss, which is clear as day. We raised in Schedule B that there's a lis pendens and a tax lien foreclosure. And if the court looks at page, it's in the tax lien foreclosure, it was asserted against Mr. Wilson that he has an unrecorded fee interest. Now, we excluded that. We told them in the policy there's an LP, there's a tax foreclosure, there's a case.
And we're not covering that.
And we're not covering that. Did they look at that? No. If they looked at it, they would have seen, oh, there's a claim Mr. Wilson's a fee owner. And they also retained their own tax search. That they paid the title agent separately. We didn't pay it. They were not authorized in my agency agreement to do it. And those tax searches disclosed Mr. Wilson as the assessed owner. So they knew he was an assessed owner. They knew there was a lis pendens, or at least they were on constructive notice that he was claimed to be a fee owner, and they proceeded with this closing anyway. Under 3A of the policy, the lower court didn't get to this. But if you want to get there, under 3A of the policy, they assumed, they went ahead and closed without going out there. They assumed the risk. That is now they are claiming they should be covered. Unless the court has any questions, I think my time is up. Thank you all.
Thank you, counsel.
Just one point, Your Honors. I believe that, I think it's important to note here that My client was not divested of title because of an adverse possession claim or his possession. My client was divested of title because of an unrecorded instrument which is specifically included under coverage. There is no exclusion for unrecorded instruments. My client was divested of title based on the strength of an unrecorded deed. Not adverse possession, not Mr. Wilson's possession. Thank you, Your Honors.
Sorry. His name's.